The number of drug cases in Florida has exploded over the last 10 years or so, particularly with the increased abuse of prescription drug and the number of prescription drug cases. The way that the Florida legislature has decided to deal with this problem is, in my opinion, very wrong-headed. They've decided to increase the penalties and make them extremely severe, sending people who are addicted to even prescription medication off to prison for a number of years. I've given a number of public speeches about this. I've lobbied the legislature to take a different approach, and I battle these cases in court every single day because I believe that the way that these cases are being prosecuted by the state and being handled by law enforcement is wrong. We have to change our approach. If you're charged with trafficking in Florida does not require the state to prove that you had any intent to sell or were selling or were distributing. Trafficking is simply possession of a certain amount of drugs. And in prescription pill cases, it doesn't take a whole lot of pills for them to charge you with trafficking. The problem with trafficking cases is they carry with them harsh, very severe minimum mandatory prison sentences. And so in these cases, these are the most serious drug cases, and you have to fight them very aggressively and find any way to get the charge either reduced to a lesser charge that's not trafficking or to beat the charge entirely in order to stay out of prison. The next most serious kind of a drug case is where you're charged with either sale or possession with intent to sell. Normally these cases, even for a first offender, carry with them, the state wants at least a minimum of 6 months in county jail. And often if you have a record, they want prison time. So it's very important, again, to aggressively defend these cases, and I'll talk about what some of the defenses that you may have to drug cases are. The other kind of less serious charge is when you're charged with possession. Depending on the drug, this can be either a misdemeanor, like with marijuana, or it can be felony, and that's when you're charged with simple possession. Now, many people that are just charged with possession get straight probation or county jail time, but it is possible, if your record is real bad, to get prison sentences just for simple possession. As I mentioned, the prescription drug abuse problem is really the most serious problem, and the majority of drug cases we see today are prescription drug cases. There are a number of defenses to these. Most people, they're legally prescribed, but they either didn't have them in their prescription bottle when they encountered law enforcement, or it was an old prescription. I want to let you know that even if you were in possession of a prescription drug, even if you weren't prescribed it recently, as long as you had an old prescription, that can be a valid legal defense. There are a lot of other defenses to prescription drug cases, particularly trafficking cases. One of the first things that the state has to prove is that you possessed it. And a lot of times, either prescription drugs or other kind of drugs like marijuana and cocaine, they're not found on you. They're either found in your vehicle, in your house, in a place that you're staying, and you may have gotten charged with it because you were near it, or because it was in a car you were driving, or under a seat where you were a passenger. Those provide a number of ways to defend, particularly if there were other people present. You don't have to necessarily point the finger or blame anybody else by name, but it's enough that your lawyer could create a reasonable doubt in your case by illustrating the fact that it could have been any number of people's drugs because it wasn't actually found on you. That's what's called a constructive possession defense, and that's the most common defense used in drug cases. There is also an entrapment defense, and that comes into play in sale cases. You may be charged with a drug offense because you sold drugs to an undercover officer and you're on video, and you may think, wow, they've just completely got me. There's no way out of this. But there is. And that most common defense that we use is entrapment. What entrapment is if you've been enticed or induced, you've been solicited either by an undercover officer or by an informant working for the police. That's the first part of entrapment. In other words, somebody working for the police came to you and initiated contact, not the other way around. The second part is that you had no predisposition. You were not predisposed. You were not out there actively selling drugs to other people at the time, and they cannot prove that you were actively out there selling drugs. A lack of predisposition is a good part of the entrapment defense if you haven't had prior convictions for selling that particular drug in the recent past. So usually when entrapment works is in cases where somebody sold to an undercover officer, had never been caught or dealing or selling drugs in the past, and where somebody acting on behalf of law enforcement initiated contact. And what the law says is if all of that has occurred, then you could be not guilty of selling because you've basically been talked into doing it by somebody working as an agent for law enforcement. Finally, a couple of the other defenses that are very common in drug cases are knowledge issues. In other words, just because something is found in a vehicle that you're driving or in a house where you're staying, they have to prove, number one, that you knew it was there, and number two, you knew what it was. And a lot of times, people think that they're guilty of possession, and officers make arrests based on that just if you're in proximity to the drug. And the law is very clear that mere proximity or being near the drug is not enough. Or even having the drug somewhere that you control or own is not enough. They have to prove you knew that it was there and you knew what it was. And that often provides a defense to a lot of different kind of drug cases. Finally, there's search and seizure issues. Even if you're completely caught red-handed, the drugs are on you, you admitted that it was yours, or you have no defense in those kind of areas, you weren't entrapped. Oftentimes we're able to get cases thrown out of court, drug cases thrown out of court, because your stop and your seizure and the search that law enforcement officers did of you was not legal. They didn't have probable cause to stop you, to pull you over, to order you out of your car, or to pat you down, or to do the search that they did. Even search warrant cases can be thrown out based on search and seizure grounds. So there are a number of different legal defenses to drug cases that we explore. Finally, if there are no valid legal defenses, if it just looks like none of those things are going to work, obviously what we're going to try to do is negotiate and minimize the damage. And what we will try to do if the state is wanting to put you in jail or put you in prison is I will find out a lot about you, your background. I'll get letters from your friends, your relatives, people in the community who know you, and try to appeal to the state that you're a productive citizen and that the best thing to do to help you is to get you a rehab or a treatment, send you to a treatment facility rather than jail. Jail and prison is not the answer to handle drug addiction. Treatment and probation is the proper way to handle it. And the state will normally agree to that as long as they feel like you are redeemable. You're somebody who can be reformed, can get put on the right track. And so as your attorney, my job is to convince them that you have a sincere desire to seek help and you want to get things turned around. So in all drug cases, the first thing we're going to do is try to aggressively defend your case. I'm going to try to find a way to get you out of the case, to get you out of the charge, to get the charges dropped. But if I can't do that, we're going to try to do the next best thing, and that's to keep you out of jail.